you made a ruling and revoked her probation, but have not passed sentence yet.
We call and that 4 cases, all styled the state of Texas versus Diane Ruben. Ms. Ruben, I recognize, is present with her attorney, Mr. West, and the state's attorneys. We have 4 cases here, 23 CR 1004. There is a second amended motion to revoke probation in that case. In 24 CR 258, there is a second amended motion to revoke probation pending in that case, where the court on that case and the preceding case we need to I think 2 of the allegations have been abandoned. Is that right, State? 2 and 3 were abandoned, and allegation 1 is the only one still remaining. You remember that?
I don't remember which one it was.
Okay.
Yes.
And then in 24 CR 1926, she's charged with assault on a public servant, as well as 24 CR 2053. 3rd-degree felonies, and those are pending.
Right, the new cases are still pending.
So what are we going to do?
Your Honor, I think today is just the sentencing on the, we had the motion of probation hearing, I don't know when it was, all that, whatever it was. We had witnesses, you made a ruling and revoked her probation, but have not passed sentence yet.
And that was on May 14th, 2025, Your Honor, that we.
Okay. Did I? All right. I've got, according to these files, I noted the number 2 was abandoned, and then I've got a ditto on 3. So 2 and 3 were both abandoned?
Yes, Your Honor.
So 1 is all we had?
Yes, sir. And we I believe I called the officer on that one, and we had them testify with the body cam.
All right. I think I need to make some final findings on that. Okay. All right. Let's handle those first. We'll pick up that. Okay. And again, Ms. Ruben's present. And in the 2 cases, 23 CR 1004 and 24 CR 258, the court earlier held hearings on those second amended motions to revoke probation. And the state abandoned allegations 2 and 3 in each of these motions to revoke probation. We move forward on allegation 1, where it was alleged that the defendant, Diane Ruben, committed the offense of assault on a public servant on or about August 21st, 2024 in Jefferson County, Texas, in violation of condition 1 of her probation order. Is there anything else to add on that matter?
No, Your Honor, except for some argument on punishment. I mean, I think we're both able to request.
The court does make a finding, or and probably will be repeating the earlier finding in that hearing, that the court finds by a preponderance of the evidence or greater that it was proven that the defendant committed assault on a public servant on or about August 21st, 2024 in Jefferson County, Texas, as alleged in each of these 2 motions, second amended motions to revoke probation, and that the court finds were assaults, acts committed in violation of condition 1 of the defendant's probation order, which is do not commit another crime. So the court finds that there is sufficient evidence in the record to support granting the second amended motion to revoke probation. What do the parties want to add in addition? Go ahead.
Go ahead, John.
State or defense.
I think you can defer to me to go first. Your Honor, I would request that you continue Ms. Ruben on probation. I think that's what she would like to do. She has been in jail for quite a bit already waiting this. And I would argue to the court that the court could use that as some kind of punishment. And then put her back on probation. If the court is inclined to sentence her to prison, I would request the leniency from the court based on her age and her even though she's found to be competent, her diminished capacity, mental capacity, for the court to go lenient and give her as minimal period of time as possible.
And Your Honor, Ms. Ruben was already given a chance. She was placed on probation in both these cases for assault on a public servant and then assault on EMS personnel. She had then, while on probation, has committed 2 more offenses, the assault again on a public servant, then also another assault on the public servant, both of those while she was on probation. We've tried to come up with a solution on what to do with Ms. Ruben. I don't think she has any family support. There's nothing there for her. If she's released, the state just believes she's going to get out and assault another either hospital staff or another public servant. And we're asking for 7 years TDC. And hopefully she'll be sent to a facility there that she can get some help. One of the women's medical facilities there, be able to give her a chance to kind of get back on her feet to transition back into going outside.
Did you want to say anything else, ma'am? Did you want to add something, Miss Ruben?
I've been in a nursing home. I've been getting help. I've been somewhere, I don't know where, it's in a police station. That's where I was, in jail. I've been in jail, and the jail teacher I cannot use it's fun. That's what I've been in. Yeah, so that's what I've been in.
All right. First of all, for each of these cases, the court, in an abundance of caution, ordered Dr. Edgar Pond, licensed psychiatrist here in Beaumont, Texas, to evaluate the defendant. And this was in April of this year, prior to any disposition of these cases. And the Dr. Krappon's report was prepared April 25th, 2025, received and made a part of the record in each of these 2 cases as court's exhibit number 1 on 5/14/25, the date we had this hearing on her motion to revoke probation. And in summary, Dr. Rapon deemed that the defendant is competent to proceed to a resolution and that she represents what he refers to as the revolving door of mental health treatment and medication noncompliance. And she has a history of multiple hospitalizations and a number of past alleged legal issues. But she has an underlying mental illness of mild cognitive decline and borderline intellectual function, which Dr. Rapon states is adequately treated in her current institutional setting where she is provided medication and monitoring, which this court hopes that the facility that she's sent to is monitors in that way, and if she is imprisoned, that the court urges the Texas Department of Criminal Justice to strongly consider sending Ms. Ruben to a hospital type prison unit for continued treatment for her mental condition. Problem she has is when she goes to a non-secure facility, she assaults medical personnel, and that puts them in danger who are not trained in handling penal type inmates who need security, in spite of the fact they are competent, and as this defendant is. So what the court had asked for a plan to in the last couple of months for the parties to come up with, and what are the recommendations based upon the research done by the parties? First of all, state.
Your Honor, the recommendation is the 7-year TDC and try and get her in a facility like Dr. Rapon recommended, where they give her some a medical treatment facility as well to help with her psychological issues, as well as trying to get her back into society. But we found no family support. I know probation's looked. Mr. West has looked. I have as well. There's no family support there. So if she's released today, again, I think we end up with her getting sent again to the hospital and
they take it all by
and repeating, what's happened, assaulting another one. So that's our concern.
take it all by.
Okay. We're going to let you talk in a minute, ma'am. Thank you.
And that's why we're asking for the 7 years.
Your Honor, I would ask for the court to be lenient based on all this stuff going on here. We've tried to find family or somebody that can help with some kind of plan of action or some kind of care plan, but we just have been unable to find anything. Like reiterate what Mr. Boyd said, probation's look, I've looked, Mr. Boyd's even done some above and beyond and looked himself. I know it's not part of his duty, but I know he's been looking. Me and him have talked about this many times, and we don't have any kind of solution that would solve this. But I'd ask for the court just to consider being lenient on any sentences.
What does that mean? What do you mean by lenient?
I would go the minimum.
That's what I wanted to go to.
Well, the concern this court has is the future danger to others by the defendant's mental and physical situation. And once again, she's declared competent, but when she's placed in the non-penal settings for hospitalization, she assaults the personnel.
Yes.
And Dr. Rapon understands and appreciates that situation, yet we don't have a clear plan one way or the other. And this court believes that a penal medical facility is in the best interest of this set of circumstances. And I can't dictate where the prison system offender in the Texas Department of Criminal Justice, but the court is going to urge those people who are in charge of the designation of the facilities to strongly consider and or urged to send her for treatment in a medical facility in the penal system. I find that there is sufficient evidence supporting these second amended motions to revoke them by a preponderance of the evidence or greater, as allegation 1 has been proven true, that she committed the offense of assault on a public servant on or about August 21st, 2024 in Jefferson County, Texas, which is in violation of condition 1 of each of these two second amended, each of these two probations in that the defendant was placed on July 29th, 2024 in cause numbers 23 CR 1004 and 028, where she was on probation for the third degree felonies of assault on a public servant. Thus, her probation is hereby revoked. She is hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. And she will be given credit for all time she has served in accordance with her custody that she's been in these cases. And once again, the court strongly recommends, based upon Dr. Edgar Pond's findings, based upon the defendant's history, that she be placed in a medical facility for these two sentences. All right. Anything else to add?
Not from the defense.
All right. We have two additional cases. What are we going to do with these? We've got two more assault on public servants, 24 CR 1926 and 24 CR 2053. These are indictments handed up on September 11th and 25th, respectively, in 2024. And the indictments also go on to allege not only the third degree felony, but it has each indictment alleges 3 prior felony convictions of forgeries and an aggravated assault. These are in sequence. So the defendant is subject to habitual felon status, which means she is looking at no less than 25 years confinement up to life imprisonment. What are y'all going to do on these two?
Your Honor, let me speak with my client about that. Mr. Boyce just made me an offer regarding these other two that would resolve it to run concurrently with what you just gave her, but let me see if she will agree to that and sign it, see if we can do it that way.
All right.
You can pass it.
Let me know.
Somebody else can
We'll keep these open for more consideration. Thank you. Very difficult, a difficult set of circumstances there.
Oh, no.